When we picture a courtroom, we often imagine this perfectly calibrated, almost mechanical system.
Right. With strict rules of civil procedure, stringent evidentiary standards, it's a highly formalized environment.
Exactly. You feed the facts into this apparatus, the gears of justice turn, and out pops a clean, fair verdict. I mean, it is a comforting image because we desperately want the law to be predictable.
Oh, absolutely. We want it to be a precise science. The architecture of the legal system is built to project that exact image of objective measurement.
Yeah, the scales of justice.
Right. Literally the universal symbol for this balanced mechanical fairness.
The messy reality, though, is that this entire machine is operated by human beings.
Yeah.
And, human judgment is incredibly complex, it's subject to fatigue, and it's notoriously slow.
Very slow. Systemic backlogs are a defining feature of almost every court system in the world right now.
So what happens when we try to solve that human bottleneck by plugging a literal, high-speed, incredibly powerful machine artificial intelligence into that deeply human process?
Well, the friction happens immediately. It is the ultimate collision between the modern demand for hyper-efficiency and the ancient absolute necessity of due process and human rights.
And that collision is the exact focus of today's deep dive. We're looking at a really fascinating piece of source material. It's an excerpt from the AI Governance Framework for Judicial Process and Administration.
Specifically, we're zooming in on Chapter 3 of these proposed regulations, which were released by the Supreme Court for public comments.
Right. And our mission today is to explore the exact boundaries being drawn around AI in the courtroom. We want to look at what it is explicitly allowed to do, what is absolutely forbidden, and ultimately how these rules aim to protect you.
Because the precedents set here, they will inevitably influence how your data, your liberty, your disputes are handled going forward.
Exactly. So whether you are a legal professional dealing with these tools every day, a tech enthusiast watching the algorithmic boundaries shift, or just someone who, might one day find themselves fighting a traffic ticket or a civil suit.
You really need to understand how the justice system balances human judgment with machine efficiency.
Yeah, you need to know who or what is making the decisions that affect your life.
And the framework we are analyzing provides a surprisingly rigid roadmap for how the judiciary plans to handle that exact issue.
Okay, let's unpack this. Can you explain the fundamental approach this regulatory framework takes? Because right off the bat, the source points out that the architecture of these rules is, well, it's entirely different from the standard tech policies we usually see.
Yeah, it really is. Most broad AI governance models, like the DGPSI AI framework that's referenced in our source, they rely heavily on a sliding scale of risk assessment.
Okay, a sliding scale, like how?
Well, they look at a specific AI application, say a customer service chatbot versus a medical diagnostic tool, and they classify its risk level. Like, is it low risk, moderate, or significant risk?
Right, that makes sense.
And then they apply regulations proportionally based on that classification. It is designed to be a fluid approach that encourages corporate innovation while mitigating the worst harms.
I mean, I can see how that works for general consumer technology, but this framework abandons that sliding scale entirely, right?
It abandons it.
Because it is built exclusively for the judiciary. The regulatory draft takes a completely binary approach. It directly defines what is permitted and what is prohibited.
Yes. There is a definitive list for yes and a definitive list for no.
Which is so interesting.
What's fascinating here is that this explicit zero ambiguity approach is highly unusual for technology regulation. I mean, tech regulation usually bends over backwards to remain tech neutral and adaptable.
Yeah, to keep up with the pace of innovation.
Exactly. But this framework reflects the supreme, almost institutional caution of the judiciary. They are unwilling to trust this technology enough to leave the rules open to interpretation.
It makes me think of a parent giving a teenager a list of weekend chores.
Oh, that's a good analogy.
Right. Like you don't just say, hey, help out around the house and use your best judgment on what's dangerous.
No, you give them an exact bulleted list.
Exactly. You will mow the lawn, you will take out the trash, and you are absolutely forbidden from driving my car. It leaves zero room for ambiguity.
Because in a legal environment, precision is everything. You cannot afford to have a third-party software vendor or a local court clerk misinterpreting a moderate risk guideline.
Not when someone's constitutional rights are at stake.
Exactly. The stakes demand that binary structure. The source notes that the section is explicit precisely to eliminate any cause for misunderstanding at the administrative level.
Okay, so let's get into the mechanics of the yes list, the permissible uses of AI. The framework outlines several areas where AI can be deployed, but rather than just reading down the list, let's look at how they actually expect this to function.
Right. Let's break it down.
For instance, I was looking at how they want to handle the massive mountain of paperwork through administrative and case management. The framework specifically allows for AI to auto-generate prescribed formats, like notices and summons, using metadata merging.
That is a perfect example of targeting the most inefficient parts of the system.
What does metadata merging actually mean in this context?
So metadata merging here means the AI software automatically extracts specific data points from a raw digital filing. We're talking names, dates, charges, addresses.
Oh, okay.
And it instantly populates the court's standardized legal templates. Instead of a clerk spending hours manually typing out thousands of individual summons, the system maps the XML data directly into the approved forms.
Wow, that's huge. Another massive bottleneck they are targeting is documentation. The framework permits the automated transcription of court proceedings and the translation of judgments.
Which is incredibly complex in practice. I mean, courtrooms are noisy environments with crosstalk, heavy legal jargon, and varied accents.
Yeah, I've read that natural language processing algorithms have advanced significantly, but they still hallucinate or misinterpret context.
Exactly. Permitting AI to handle the first draft of these transcriptions is a massive time saver, but it introduces a severe point of vulnerability if the record of what was said in court is inaccurate.
And that vulnerability brings up the massive caveat I noticed in the text. I was reading through these permissible uses, expecting a tech revolution, but I realized none of this is autonomous.
Not a single allowed use operates independently.
Right. The text mandates that any permissible use requires prior approval in writing from an appropriate authority. Furthermore, specific tasks demand mandatory human oversight.
The safety nets are woven into every single process.
They really are. That automated transcription we just talked about. The text states it is subject to mandatory review and certification of accuracy by a designated officer.
Right. A human has to sign off.
And the translation of judgments requires human verification of fidelity to the original text. Even if the court uses AI for document fraud detection, the rules state it is subject to mandatory human review of all outputs before any action is taken.
If we synthesize the mechanics of all these rules, the framework is really relegating artificial intelligence to the role of a highly capable but fundamentally untrusted intern.
That is the exact vibe. The intern can do the heavy lifting. They can sort the massive backlog of files, run the metadata merge for the summons, and even do the precedent retrieval to find old case law.
But they do not have the authority to actually file anything or make a final determination.
Right. A senior human official must always review their work, verify every citation, and physically sign off on it before it enters the legal record.
The judiciary is more than happy to utilize the processing power of AI to clear their desks, but they are retaining absolute unyielding ownership of the final product.
Because the judge or the designated officer is the one who ultimately answers for any errors.
Exactly.
But, knowing that every single permissible use requires prior written approval brings up a major logistical question. Who is actually doing the approving?
Well, the text states that the appropriate authority handles this, defining that authority as the AI committee in the Supreme Court, or the respective high courts across different jurisdictions.
Yeah, and they also stipulate that any use not explicitly listed in the framework's illustrative list requires prior written approval, complete with recorded reasons for granting or refusing the software.
Right. They have to document exactly why they said yes or no.
Here's where it gets really interesting, because I have to admit, I'm completely baffled by the logistics of this deployment strategy. The framework is incredibly strict, yet it hands the tech approval power to dozens of different committees across various high courts.
It's a valid concern.
Why would a centralized framework intentionally fracture its own software deployment? The source material points out this exact flaw, noting we could end up with a wildly messy, decentralized situation.
You are hitting on a massive tension within the judicial system right now. It's the desire for standardized technology versus the fierce protection of local administrative independence.
Right, because high courts operate as independent administrative bodies for their respective states.
Exactly. They manage their own dockets and often have their own specific local procedural rules.
But software doesn't care about local procedural pride. If High Court A approves a specific AI scheduling tool and High Court B rejects it because of a minor API mismatch with their legacy system, you suddenly have a fragmented technological ecosystem.
And if High Court C decides to approve a completely different competing software vendor, the national legal system is suddenly speaking 3 different digital languages.
Which sounds like a nightmare.
It is. The source notes this fragmentation is entirely avoidable. It argues that software approval should be the sole responsibility of a centralized technical committee.
A single, unified body evaluating an AI tool once, stress testing its security, and then issuing a standard nationwide ruling.
Yes. If precision and consistency are the ultimate goals of this framework, having multiple different committees making independent technical evaluations seems counterproductive.
It really highlights the severe growing pains of a traditional institution colliding with rapidly scaling technology. Standardized software deployment requires centralized architecture, but the legal framework is still clinging to a decentralized administrative model.
That's exactly it.
Okay, so moving from the flawed approval process, we arrive at the hard boundaries, the absolute do-nots. This section of the text lays out where AI is entirely unequivocally forbidden from operating.
The source refers to these prohibitions as absolute and non-derisible.
And that specific legal terminology is crucial, right?
Oh, absolutely. It means no authority, not even the decentralized committees we just discussed, can relapse or modify these rules under any circumstances.
The door is slammed shut and dead-bolted.
Precisely.
I want to break down these bans because they get to the very core of what a court is. First, the framework explicitly bans algorithmic decision-making for judicial outcomes.
Meaning no judgment, no order, no finding of fact or law can be reached solely based on AI-generated analysis.
Exactly.
If we connect this to the bigger picture, we are seeing the philosophical core of the entire framework. The judiciary is drawing a line in the sand regarding the nature of legal adjudication.
A machine can calculate probabilities, but it cannot dispense justice.
Right, because justice requires context.
And the framework backs this up by stating no AI system can perform the function of adjudication or sentencing without a mandatory human in the loop.
And even then, any output from the AI regarding a sentence is strictly classified as advisory. It is subject to independent judicial evaluation.
The mechanics of that human-in-the-loop requirement are fascinating to me. If an AI analyzes a contract dispute and spits out a recommended damages figure, the judge cannot simply rubber stamp it.
No, they must independently evaluate the logic. But, if the judge has to do the substantive legal analysis anyway to verify the AI's conclusion, it begs the question of how much time the AI is actually saving in the adjudicatory phase.
Right. It almost seems like the framework is intentionally introducing friction into the sentencing and judgment phases to prevent automation bias.
That human tendency to just blindly trust the computer.
Exactly. And the framework also extends this caution to the evidence itself. You cannot submit an AI-generated output as an independent source of evidence without fully and transparently disclosing its AI origin.
Which makes sense. We are entering an era where deepfakes, synthetic audio, and AI-generated financial summaries can be virtually indistinguishable from reality.
Yeah, it's terrifying.
The framework recognizes that admitting opaque AI outputs as evidence fundamentally destroys the opposing counsel's ability to cross-examine the source.
Right. And that protective stance logically flows into the next major section of bans, which shifts from protecting the judge's authority to protecting the individuals interacting with the court.
The public.
Yeah. This is where the framework actively bans what I can only describe as the sci-fi Minority Report scenarios.
You're talking about the prohibitions on predictive profiling and surveillance.
First off, no personal data can be used to train, test, or refine an AI system without prior approval and strict compliance with broader data protection laws.
A baseline privacy guarantee.
Right. But then it gets deeply into the predictive tech. The text explicitly bans risk scoring. It states no AI can be used to assess flight risks, predict recidivism, evaluate bail eligibility, or determine the credibility of witnesses.
It is a total rejection of statistical correlation as legal causation.
I have to admit, I am amazed by the firmness of this ban. I mean, if you look at the sales pitches from major legal tech companies right now, they are aggressively pushing predictive algorithms.
Oh, it's a massive industry.
Yeah. They sell software claiming to analyze a defendant's background, zip code, and employment history to tell a judge exactly how likely they are to skip bail or reoffend. So what does this all mean for the future of courtroom tech? Are the courts just completely opting out of the next generation of predictive software?
They are opting out of the black box algorithm in the pursuit of justice, and honestly, it is a massive victory for civil liberties.
How so?
Well, Predictive policing and risk scoring algorithms work by analyzing past demographic data to predict future behavior. The framework recognizes that relying on statistical prediction to determine an individual's future is inherently prejudicial.
Because you are literally judging someone based on the past actions of other people who happen to share their demographic markers.
Precisely. And the framework goes further by explicitly banning the use of opaque or unexplainable AI systems that could materially affect someone's lawful rights or personal liberty.
Unexplainable AI.
Yeah, this targets how modern neural networks actually function. Data goes in, the system forms billions of hidden layers of logic, and a conclusion comes out. Even the original programmers cannot always mathematically trace the exact logical steps the machine took.
But in a court of law, due process demands a reasoned order. If a judge denies you bail, they have to write down exactly why.
Exactly. They have to explain the legal reasoning so you have the fundamental right to appeal it. You cannot cross-examine a hidden layer of a neural network.
Right.
If a machine labels a defendant a 78% flight risk, but cannot transparently show its math in a way a human can debate, that violates the core principle of a fair hearing.
So by banning unexplainable AI and risk scoring, the judiciary is making a profound philosophical statement. They're saying human beings are too complex and their liberty too sacred to be reduced to statistical probabilities. The boundaries are firmly set. But that leads to the natural final question we have to ask when looking at any regulatory structure: enforcement. What happens when a vendor or a clerk breaks these non-derogable rules?
Well, the framework does attempt to establish a strict mechanism for accountability.
Right. The source material outlines the remedial measures, stating that every violation of these prohibitions must be reported forthwith, meaning immediately, to the AI Secretariat.
And this report is placed before the AI Committee, which conducts a due inquiry and directs remedial measures, explicitly including the outright suspension of the relevant AI system.
So they establish the authority to pull the plug entirely.
Yes.
But here we run into another critique from the author of the source notes. Just like the flawed, decentralized approval process, the author points out a massive blind spot in how these violations are handled.
Which is?
The source notes it would be highly preferable to clarify that violations must be reported to a central committee.
This raises an important question about systemic security and what we call jurisdiction shopping.
Yeah. Let's say a vendor's AI system starts hallucinating legal precedents, or worse, a local court discovers the vendor quietly integrated an algorithmic risk scoring module into their case management software.
Right.
The local high court committee catches it, conducts their inquiry, and suspends the system in their specific jurisdiction.
But without a mandatory centralized reporting and enforcement structure, that vendor could simply take that exact same faulty software and continue operating it in another court jurisdiction on the other side of the country.
Exactly. The author's critique is spot on. Centralized reporting is the only way to ensure that once a system crosses the line and violates a non-derogable rule, it is purged from all courts simultaneously.
Because if you have a zero-tolerance policy for AI misconduct, you cannot rely on a patchwork of local committees to enforce it. A decentralized enforcement mechanism in a digital ecosystem is effectively no enforcement at all.
A malicious or poorly coded AI will simply migrate until it finds a court that isn't paying close enough attention to the technical specifications. Looking at the entire document, it is a fascinating, highly defensive balancing act. To summarize our deep dive, the judiciary is letting artificial intelligence into the building, but strictly as an administrative workhorse.
Right. They are unleashing it on the dockets, the translations, and the metadata merging to clear the massive paper jams.
But simultaneously, they have built an impenetrable wall to keep AI completely out of the actual business of judging.
The human mind remains the only approved processor for legal adjudication. No machine sentencing, no algorithmic profiling, and no statistical assumptions about human behavior.
It is a profound defense of human agency within the justice system. But, it leaves me with one final provocative thought, something for you to ponder long after we wrap up today.
Cool.
We talked at the very beginning about that messy, slow human machine of justice. We know that systemic backlogs are plaguing our courts. People routinely wait years for a trial, which in itself is a denial of justice.
The constitutional right to a speedy trial is constantly at odds with the sheer volume of cases.
Right. So here is the ultimate question. If we absolutely require a human in the loop for every single substantive legal analysis, and we strictly ban AI from using predictive logic or statistical sorting to speed up case resolutions, will technology ever truly be able to solve the massive backlogs in our legal system?
It's a huge question.
Or is this strict, uncompromising framework an ultimate admission that true justice, by its very definition, is inherently slow, incredibly inefficient, and profoundly, inescapably human?
The tension between efficiency and equity really is the defining legal challenge of our generation.
And it seems the courts have made their choice. Thank you for joining us on this deep dive. Keep reading, keep analyzing, and always keep questioning the systems and the algorithms operating around you.